Welcome back to the Winning Brief Soundbites. I'm Mabel. In the next 5 minutes, we're going to look at the EU AI Act, the world's first comprehensive law on artificial intelligence. By the end of this episode, you'll be able to explain the Act's risk-based structure, understand why it already applies in part, and practice phrases you can use when discussing AI regulation with colleagues and clients. The European Union published the EU AI Act in its official journal on 12 July 2024, and it entered into force on 1 August 2024, making it the first comprehensive legal framework governing artificial intelligence anywhere in the world. But here's the key point. The Act does not apply all at once. It uses a phased rollout. The first provisions banning the most dangerous AI systems started applying on 2nd February 2025. Rules for general-purpose AI models became applicable on the 2nd of August 2025, and the bulk of the obligations, particularly for high-risk AI systems, will apply from the 2nd of August 2026. So how does the Act actually work? Well, it uses a risk-based approach. The Act classifies AI systems into 4 categories: unacceptable risk, high risk, limited risk, and minimal risk. The higher the risk, the stricter the rules. At the top, the Act bans outright any system that poses an unacceptable risk. These include AI that manipulates human behavior, social scoring by public authorities, and, with very narrow exceptions, real-time remote biometric identification by law enforcement in publicly accessible spaces. Why does this matter to you as a lawyer? 3 reasons. First, the EU AI Act represents a regulatory landmark. Just as GDPR reshaped data protection globally, this act sets the standard for AI governance. Jurisdictions around the world are watching. Second, the obligations extend beyond tech companies. The Act applies to anyone who deploys AI, and that includes law firms. If your firm uses AI for contract review, research, or drafting, you need to understand how the Act classifies those tools because the risk level determines your compliance obligations. And third, you cannot afford to wait. Parts of the Act already apply. Lawyers who understand this framework now will position themselves to advise clients and to protect their own firms. Now, let's look at some of the phrases we just covered. 1. It uses a phased rollout. Phased rollout means you bring something into effect in stages, not all at once. 2. The Act classifies AI systems into 4 categories. Classifies into is a key construction in legal English. The verb classify tells your audience you are sorting things by a set of criteria. 3. The obligations extend beyond tech companies. Extend beyond means the scope reaches further than you might expect. It broadens an argument efficiently. 4. You cannot afford to wait. Short, direct, and urgent. Legal English rewards this kind of directness. 5. Lawyers who understand this framework now will position themselves to advise clients. Position yourself means you place yourself in an advantageous spot. It works very well in professional speech. Now, time to practice. Repeat after me. It uses a phased rollout. The Act classifies AI systems into 4 categories. The obligations extend beyond tech companies. You cannot afford to wait. We want to position ourselves as trusted advisors on AI regulation. Well done. In part 2, we go deeper. We look at what the Act actually bans and what it means to operate a high-risk AI system in the EU. Until next time, keep practicing. If this conversation resonated, I work with lawyers and legal teams who want to operate more confidently in international and EU level English. You can find my work and book a conversation at thewhinningbrief.eu.